evidence that was led by my senior Otiende Amolo, then we reached the inescapable conclusion, and we invite your Lordship to find that there was two systems operating under IEBC. One that the public was made to believe had all the specifications and security features under the ICT regulations, and one that nobody knew about that only IEBC can explain. It is under those circumstances that the fake or fraudulent Form 34s could have found themselves in the web portal and also found themselves before your Lordships as evidence presented as Form 38. So those are my submissions. Thank you.
There's one point that I raised. You haven't responded to it. We agreed that this is not a dying declaration. Therefore, you should say something about its evidentiary strength.
Yes. Thank you, my Lord. I think this came against the background of very serious integrity questions or confidence questions that are being asked by the people of Kenya about the preparedness. And your Lordship and my ladies will find that there are materials that we have placed in our petition where the petitioner's political party or alliance raised several questions about the preparedness of the commission, questions about procurement, and questions about the KIMS kits that were going to be used. I believe it is against this background that it became necessary for IEBC to come out and impute or give that confidence to the people that we've put in place a system that will work. Unfortunately, that system did not work as Musando had contemplated.
Yes, my lords, with your permission, I just want to wrap up the submissions that we've made so far and conclude this component of the proceedings of the court. And I hope not to take more than 20 minutes, at least save some time. My Lord, we have to decide whether the provisions of the Constitution, particularly the provisions that relate to supremacy of the Constitution, are binding on all state organs and all persons, or they are provisions that can be overlooked. My lords, if you look at Article 2, sub-Article 4, it says, any law, including customary law that is consistent with this Constitution is void to the extent of the inconsistency, and any act or omission, this is where I want to put the emphasis, any act or omission in contravention of this Constitution is invalid. My Lord, this is a provision that this court cannot overlook. And when we interpret the Constitution, and the tools of interpretation are given in, I believe, Article 259. And in that Article 259, you find, your Lordships, that one of the interpretative tools says that the Constitution shall be interpreted in a manner that promotes its purposes, values, and principles. So I want to pose the following question, your Lordships. And when you retire, probably you'll consider it amongst many other matters that have been placed before you. Men and women of faith, particularly Christian faith, to which I belong, and I'm an Anglican, in religious or heavenly matters, there is either heaven or hell. In some religions, there's a place called the purgatory that you can rest for a while. Depending on circumstances, you can go either side. But I think your Lordships, in matters constitutional, and using the tools of interpretation, the court has to make a decision whether acts of persons or state organs are valid in accordance with the Constitution or whether they are not valid. And we are a constitutional democracy, and these questions are critical. And therefore, in looking at this petition as a whole, when you crystallize some of the issues that you may have to look at. For example, one of the key questions that your lordships and my ladies would want to consider: did the winning candidate get 50% plus one? Now, that question may be a valid question in circumstances where there was a proper election held. But, my lord, if it's an election where evidence has been placed before you of systemic and widespread violation of the Constitution and the law, that question becomes moot. Because if you look at now the litany of violations that we need to look at in consideration of this matter, and particularly as put before you by my learned friend, Mr. Otiende Amolo, my lords and my ladies, you cannot ignore this factor about ungazetted polling stations. That is a matter you cannot ignore. And in looking at whether or not ungazetted polling stations could be considered in trying to compute the numbers which were garnered by both candidates, that question cannot lead this court to come out with a numerical answer. Either the station was ungazetted or ungazetted. When you look even at the question of rejected votes, my lords, on account of your decision, and I don't want to revisit this matter, in respect of how this election was conducted and looking at the number and volume of rejected votes, and without having the possibility of determining whether these rejected votes were as a consequence of the voter or the IEBC. My lords, the question of answering whether or not those 500,000 votes should have been rejected or not rejected is very difficult in these circumstances, especially a petition being held in these circumstances without the ballot boxes and the ballot papers being placed before your lordships. If, my lords, you consider the question of ungazetted officers, returning officers and presiding officers, what does this court make out of their action or omissions? Again, that question cannot be answered in such a way that can help this court compute on a numerical basis who won or who lost these elections. And then, my lord, there was a question of the use of undefined statutory instruments. These are the Form 34A and 34B. In fact, the evidence that I referred to, nearly all those Form 34B as contained in document number 7, I think. Nearly all of them did not bear all the features as required. Again, these were forms that were coming from constituencies. It makes it very difficult for this court now to go and determine who got the most votes or who got more than 25% in more than half of the counties in the Republic. And, my lord, then it comes to the constitutional role of the IEBC, which is not only contained in the general sections of the Constitution, but also what my learned friend, or rather Professor Mutaha Kangi referred to, its responsibility and burden to conduct its affairs in accordance with the Constitution. Can the IEBC be placed in such circumstances where we are the ones expected to prove the law of the Constitution, or circumstances where it is before you can take a value whether or not include trickery and alteration of statutory documents, which are important for purposes of recording the results of the elections. So, before you look that has been placed before you. And our submission is that these forms and documents do not tell a tale of an election held in accordance with the Constitution and the applicable law, which is the Elections Act. My Lord, in conclusion, I'm just being reminded that the video that just have been played, Mr. Musando was speaking in his capacity as a public official. He was giving a message to the country and thereby generating a legitimate expectation of the people of Kenya that elections will be conducted in a certain fashion. Lordships, we believe that we have placed before you sufficient grounds, sufficient evidence to void this election and to grant the prayers as contained in the petition with cause. We thank you, and I want to express our appreciation of the patience of the court since we started making this presentation. Thank you.
Thank you very much, Honorable Orengo, and thank you for giving your time. We have an interested party who is supporting the petition. Who was that? Can you give him while as counsel for the petitioners move out of the front bench, and as the counsel for the interested party takes his seat, I would request IEBC counsel to also take their seats on the front bench.
Thank you, my lords and my ladies. My name is Elias Mutuma. I appear alongside Mr. Muhatia for the second interested party, Dr. Ikuru Okot. My lords, we have filed our main response to the petition, which comprises of affidavits sworn by Dr. Ikuru Okot, another one sworn by Mr. Martin Gavole, who is the Secretary General of that Alliance Kenya. We also have an affidavit sworn by Andrew Njoroge, who is the Director of Operations of the Alliance, and the final affidavit sworn by Miruru Waweru, who is the Chairman of that Alliance Kenya. We should be relying on those affidavits and evidence on record. We shall also rely on our notice of motion application and the affidavits therein. That notice of motion is dated 21st August 2017. Now, my lords and my ladies, for the record, my client is not challenging the results of the election. We are more concerned with the qualitative aspect of this petition. Considered based on the numbers. But that did not mean it gave the process of we think and we by Professor Beck, which is appearing in our list of it's page 49. With your kind permission, I may read your lordships, where he says that same time, that form, that 4B, the one that was supplied to Mr. Waweru at Bomas, had no totals. The form that was introduced at the public portal bears totals. That same form had 3 agents, including one Hesbon Mukabi, but when it appeared at the public portal, the name of Ezron Mukabi was replaced by one Moses Mwadhi, who was introduced as an agent. You'll find this at page 99 and 98 and 99 of our notice of motion application. This clearly indicates, my lords, that we could not be talking about the same statutory form that was uploaded at the polling station. These are 2 different forms. Or if it is the same, then there was room for manipulation of that statutory document. It is worth to note, my lords and my ladies, that our only contention and the issue that we need this court to determine is what constitutes a statutory form and what is the effect of not complying with a statutory form, or rather using a form that does not qualify to be a statutory form. My lords, at page 101 of our notice of motion application, I refer you to another county, Nakuru still, but Kuresoi South. You find that at the National Tallying Center, the form that was supplied to Mr. Waweru and other agents of Dr. Ikurwa Court had no totals at all. When the same form appeared at the public portal, we had totals. That form had one agent by the name Samuel Isahao. When it appeared at the public portal, there was no agent who had signed it. That again raises a question as to whether we are dealing with the same form that had been uploaded at the polling station. You mean at the polling station it had no total? Yes. The form that was supplied to the agents at the National Tallying Center during the date of the tallying, that form did not have any totals at all. Our presumption or understanding is that that form might have or should have come from the polling clerk himself who was conducting the elections. How then now we have the same form with totals is a mystery. And the only explanation is that someone, of course, added the totals, meaning there was room to tamper with that form. My lords, Mr. Waweru has again talked about how they understood the tallying process would be, because this was supposed to be an integrated process. Form 34As gave rise to Form 34Bs, meaning that because this is an integrated system, if you were keying in results from the polling stations, then what would appear at the constituency tallying center would be a total of what is being keyed in from the polling stations. My client, through his agents, engaged Mr. Chiloba on that issue on the 10th of August 2017, asking him why we have Form 34Bs being manually generated as opposed to them being automatically generated by the system. And Mr. Chiloba admitted that they were using Excel to manually key in the results from the polling stations. Because of that, my lords and my ladies, our agents again went ahead to look at the Form 34As because enough curiosity has been raised by the anomalies that were being witnessed. And there were other observations with 34As. One is that inasmuch as the forms bore serial numbers, those serial numbers were not being used sequentially. We had a lot of gaps between one form and the other in the same polling station. My lords, at page 84, 85, and 86 of our main response, you will find a polling center known as Thika Technical, which had 6 polling stations. At polling station number 2, the Form 34A that was used, both the last numbers were 471. The next polling station in the same center bore 489. There was a total of 18 forms that would miss between 71 and 89. Now, the way we understand, my lords and my ladies, is that the purpose of putting serials in documents is for accountability purposes. And for you to secure that accountability, you must use the documents one after the other. Otherwise, it beats the whole purpose of having a serial in a document. I could go on and on, but I only realized that I have 6 minutes remaining. I refer your lordships and my ladies to page 76 and 77 of our main response. These anomalies continue to recur. What does this then mean, my lords and my ladies? Is that under Article 86, the IEBC had the duty to ensure that all the election materials, and when I talk about election materials, they include Form 34As and Form 34Bs, to ensure that they put in place appropriate structures and mechanisms to eliminate electoral malpractices, including safe keeping of election materials. If we had Form 34As that were scattered all over, that were at the disposal of the polling clerks, the returning officers, without any form of accountability, without a requirement that they should be used in an accountable manner, then that is a failure on the part of IEBC to secure election materials. My lords, the effect of this is that it impeaches the results that were announced. Because the results should be a product of a fair process. At page 48 of our list of authorities, we have annexed a judgment by Justice Denaola in the case of Bernard Shinali Masaka versus Dr. Boni Kalwale, and I'm looking at paragraph 53, where Justice Denaola says, I agree with the learned judge, and I also agree that the chaos apparent during almost all elections may lead to innocent errors. However, there is no way of authenticating an election by use of statutory form. If there is no way of authenticating an election by use of statutory documents, the results become irrelevant because the whole process is as crucial as the final results. My lords and my ladies, that reasoning and holding is true today as it was 6 years ago when it was delivered by Justice Denaola. In conclusion, we do not expect that an election process will be perfect. There is no process in life that can ever be perfect. However, we must have minimum standards to be imposed upon election managers. And where the election managers fall short or below those standards, then the courts should hold them accountable. In this matter, the court ought to review the actions of the first and second respondent as against the standards that have been set by law and establish whether the qualitative aspect has been achieved. If it finds that the malpractices were so serious as to impeach the process, then the results must be impeached as well. We submit that the statutory documents that were used by IEBC were not verifiable, they were not accountable, and they were open to manipulation. That's all, my lords and my ladies.
Thank you very much, Mr. Tuma. That's great. So, yes, Mr.
Yes, my Lord, the Chief Justice, my Lords, my Leaderships, for the record, the first and second respondents.
Just a minute. We're setting the what? We're setting the time.
Oh, you need to start again then.
Yes, what? Oh, 90 minutes, okay. Yes, okay. Yes. Very well, okay. You can start now.
I was saying, for the record, the first and second respondents rely fully on the joint response filed, which is on the court record, and which I'm sure, with all the other documents, in the fullness of time, your lordships are going to read. We also rely on the affidavits filed, including one by the chairman of the commission, one by the chief executive of the commission, one by Immaculate Kasait, one by Muhati, and a number of others from a number of presiding officers. We rely on all these. We rely on our written submissions, and we rely on our bundle of authorities. Now, because of time constraints, we will not be going into them because we are quite confident that the court will be reading these. My Lord, because we filed joint responses, joint affidavits, and that sort of thing, we intend to answer the submissions from our opponents in the following order. Once I finish, Mr. Paul Nyamondi will submit on the issue of ICT so as to respond, followed by Issa Mansour because of the numbers and the forms. Then the electoral process will be addressed by Kamau Karori. When we have done that, we have every confidence that it will become manifest that there is no substance in the allegations made, misreading of numbers, in the misrepresentation, because each one of those will be explained. I just want to point out at this point in time that actually, when our opponents were addressing the court, they merely kept repeating the narrative they had set out in their petition, in their supporting affidavit, although they had been served with our documentation, which was clarifying and setting out the factual position in respect of each one of those things. But they addressed the court as if they had not read our explanations of the factual positions. My Lord, Article 1 of the Constitution, which has been referred to by Senior Counsel James Orengo, in terms of its importance, I agree, I endorse. In fact, it is significant that it is Article 1, the sovereignty of the people. Because the 2010 Constitution places the people of Kenya at the very center. Sovereignty of the people. As my lords are aware, even your lordships, when they sit to adjudicate, they are exercising delegated authority of that sovereignty. The importance of that, and this is where perhaps I part company with the Honorable Orengo, is in the application of Article 1 with regard to presidential elections. If the people are sovereign, my lords, as Article 1 says, and that is not in dispute, one of the most profound ways in which the Kenyan people exercise that sovereignty is when they elect their president. It's the highest form of the exercise of the sovereignty, because the president, his or her constituency is the entire Republic of Kenya. That's why the Constitution requires the president to be elected by more than 50% of the votes cast, plus a minimum number, 25%, in a majority of the counties. They are exercising their sovereignty. My submission is this, that in a dispute relating to presidential elections, the fundamental issue for the court to ascertain is the will of the Kenyan people when they exercise that sovereignty. Once, on the basis of the evidence laid, on the basis of the law, your lordships are satisfied that the Kenyan people exercised their sovereignty and decided who was to lead them as their president. This court, in my submission, must be very slow in interpreting the law, the Constitution, the statute, in a manner that would fly in the face of that sovereign decision by the Kenyan people. there would have to be very good reasons. Your Lordships would have to be satisfied that in this particular case, perhaps the Kenyan people did not exercise their sovereign decision. And therefore, my Lord, in the matter before your Lordships, Lord, you have not been told that there was anything wrong at the polling stations. And it is our submission that the sovereign will of the Kenyan people is captured and can be ascertained by looking at Forms 34As. This Form 34A needs, repeat, in terms of clarity, at the conclusion of the voting, the presidential ballot in a particular polling station would be emptied on the table. The ballot papers would be counted, each for each presidential candidate, and the votes cast for each candidate will be entered in handwriting of the presiding officer in Form 34A. These then are aggregated at the constituency level in Form 34B. What point am I making here? The point I'm making here is that it is next to impossible to rig elections at the polling station level. If you want to know the will of the Kenyan people, the sovereign will of the Kenyan people, let us look at Forms 34A. And all the observers, national and international, no one has said that there was anything irregular in the counting of the votes at the polling stations. So looking at the originals of Form 34As should disclose how the Kenyan people, exercising their sovereign authority, decided who was going to be their president. And that's why, my Lord, the client I represent, the clients we represent, the commission and the chair readily agreed to the verification by the registrar of this honorable court supervising an inspection of those original forms in order to compare them with the forms that were scanned and transmitted to the National Tallying Center. Because if there was anything wrong, and I'm not suggesting there was, it will become manifest, because then the numbers in the total of the original forms handwritten at the polling stations, if there was any interference, any manufacturing, any fabricated, that will automatically appear because the numbers then will be different. My clients are confident that the numbers will be identical, and therefore that there is no doubt at all. The commission merely facilitated the Kenyan people exercising their sovereign authority. My Lord, I am constrained because of time, but I would draw the court's attention to our written submissions, paragraph 5 to paragraph 26, where we demonstrate that we carried out these elections strictly in accordance with the Constitution, in accordance with the law, and in accordance with the regulations. We have said that very clearly. My lords, you then, if in terms of respecting the exercise of the sovereign will of the Kenyan people, then I would submit that you should decline the invitation which has been extended by our opponent. But if you find any transgression of any regulation, of any section, then you must nullify these elections. You've been told time and again that it is not a question of numbers. That if any law was transgressed in whatever trivial manner, that you must nullify these elections. That would be a wrong interpretation and application of Article 1 in terms of the sovereign will of the people. Once you are satisfied on the basis of the evidence, as we are sure you will, that a majority of the Kenyan people whose decision, whose sovereign decision is captured in these forms, then you are perfectly entitled, in fact, I would submit, duty-bound to give effect to that decision and to make the finding that the returning officer, the national returning officer, was perfectly right in declaring the third respondent, who is the president-elect, duly elected. It pains my clients, the commissioners, to be vilified. They took office in a few months to the elections. And they put in all these arrangements. They've carried out a credible election. They're being vilified. I've been telling them to take comfort from that passage in the Bible that says to toil and to ask for no reward. Because whatever they do, the losing party will always vilify them. And it's a passage that I would say should also commend itself to your lordships. Because whatever you decide, just follow the law where it leads you, follow the evidence where it leads you. I would like to ask Mr. Nyamodi to take over. We'll try as much as possible to finish our submissions within the time that you have allocated to us. I thank you.
Thank you. Thank you. Thank you very much, Mr. Mwite. Mr. Nyamodi.
My Lord the Chief Justice, members of this court, I want to pick up from where my learned senior colleague has left off. And, my lords, I want to submit on 3 areas in response to the petition that is before you this afternoon. Other than the area, my lords, that learned senior had introduced that I would cover, the area of ICT, I wish my lords to respond to the important question of who is the down in a presidential election. And, my lord, the related issue what is the presiding officer is required to show those agents who are present the figures that he has entered in his or her gadget. Now, the numbers or the figures that are entered in the KIMS gadget are then transmitted directly or then transmitted directly to an IEBC server. Those figures then, my lords, made their way directly onto the screens that we then all saw the figures, and it is the screens that have been erroneously referred to by the petitioner as the public portal. That was not the public portal, and I will demonstrate, my lords, shortly what the public portal was. The image is simultaneously transmitted to the Constituency Tally Center and at the same time to the National Tally Center. My lords, a brief explanation at this point is important. The figures that have caused the petitioner particular discomfort in this matter that found their way onto the screens were prior to the decision of the Court of Appeal in Civil Appeal number 105 of this year, the Maina Kiai decision, known as provisional results. My lords, after the surgery, my lords, that was conducted on the Elections Act by the Court of Appeal, where the Court of Appeal declared the provisions of sections 39(2) and 39(3) of the Elections Act to be unconstitutional, the upshot of which was to get rid of provisional results, those figures, or those figures that were manually entered into the KIMS kit, had no status in law. They were not results. And my lord, it has been stated in the various responses that have been filed on behalf of the first and second respondents that those figures, my lord, did not go in any way whatsoever to determining the outcome of the result or the outcome of the presidential election that was conducted by my client on the 8th of August this year. The reason, my lords, why those results or those, that data was relayed by my clients is that by the time the Court of Appeal rendered its decision in the Maina Kiai matter, the system of transmission had been set up. The procedures for training presiding officers were already in place. And my lords, it was a very easy choice on the part of the first respondent, either to try and rejig the system of transmission with the real possibility that by the 8th of August there would have been absolutely no mode of electronic transmission, or leave it as it was and then abide by the decision of the Court of Appeal in the Maina Kiai decision. And I will demonstrate shortly, my lord, how the first respondent then structured the system of transmission or the pathway of transmission so as to abide by the decision in Civil Appeal number 105 of this year. My lords, there is a third component of the result that is still at the polling station. The number that has been entered in the KIMS kit has been entered and it has been sent. The image of the form 34A has been taken and it has been sent. But my lords, the hard copy of the form remains at the polling station. It is still at the polling station in the journey towards a result. Once that form or once that process is completed, then that hard copy of the form 34A is physically taken or manually taken by the presiding officer to his returning officer in the constituency where his polling station resides. the electronic form of transmission, that is the image, is the form of transmission that was prescribed by the Court of Appeal in the Maina Kiai decision. According to the Court of Appeal, the image of the form was the result, and I submit that the image was transmitted. But my Lord, other than the Maina Kiai decision, the other controlling provision of the law in respect of transmission of results is the provisions of Section 44A of the Elections Act. And my Lord, without taking up your time, too much of your time to read the provisions of Section 44A, what Section 44A of the Elections Act provides, it creates an obligation on the first respondent to put in place what the law refers to as a complementary system of identification of voters and transmission of results. My Lords, there was intense litigation about the provisions of Section 44 in the courts below this court in the run-up to the elections, in Section 44A, and it was confirmed, my Lord, by the Court of Appeal in Civil Appeal number 258 of this year, and that decision appears at pages 1 to page 13 of our supplementary list of authorities, that the complementary system that was put in place by the first respondent for the purposes of the transmission of results, which complementary system is found in Regulation 83 of the Elections General Regulation, which is the physical delivery of the form, was lawful, was in place, and by extension was available for use by the first respondent. But my Lord, at this juncture I wish to submit that unlike the provisions of Regulation 69 of the Elections General Regulations, which put in place a complementary system for the identification of voters, which provides that where the main line or the front line system fails, then you resort to the complementary system. In respect of the transmissions of results, the two systems of transmission of results are not mutually exclusive. A result is a result properly conveyed if it is electronically transmitted, according to the edict of the Court of Appeal in Civil Appeal number 105 of this year, or manually delivered via the complementary system that the first respondent is obliged to put in place by Section 44A of the Elections Act, and is indeed in place and resident in Regulation 87 of the Elections General Regulations. It has been, again, the subject of intense litigation. There was litigation, I believe the decision was rendered on the Friday before the general election in Civil Appeal, I have referred to it already, number 258 of 2017, where the appellant in that matter sought to persuade the Court of Appeal, and I have had that argument urged before your lordships this morning, that elections in this country are exclusively electronic. The purpose of such an argument, I am not sure what it is, but my lords, I can only hazard a guess, would then be to render any results that are delivered via the complementary system to be either unlawful, illegal, or even outrightly unconstitutional, my lord, seeing that elections in this country are held as directed by the Constitution and the law. The Court of Appeal didn't agree with that argument. Your lordships will see in the brief decisions that the three judges of that court rendered that it stated that elections in this country are not exclusively electronic. And therefore, my lords, I submit again that results delivered either electronically or manually are results for the purpose of an election. My lords, in respect of the presidential election, in respect of an election for president, there is a slightly different direction that pertains only to that election and not to any of the other elections. And that direction, my Lord, is to be found in section 39(1), capital C and small c of the Elections Act. That provision is to be read together with the provisions of section 44A. And it is our submission for the first respondent that it is apparent from the responses that have been filed for the first respondent that the results were transmitted according to that statutory, regulatory direction and the interpretation of the Constitution, statute, and the regulations by the Court of Appeal. My Lords, at this juncture, I wish to submit that the forms 34A received electronically by the IEBC at the Constituency Tally Center and the National Tally Center are then uploaded into a public portal. That public portal, my Lord, or the details of that public portal are to be found in paragraph 29 of the replying affidavit of Mr. James Muhati. That was the public portal for the purposes of compliance with the statutory provisions that directed the first respondent to make the 34As available on a public portal. The data that was displayed on the screens that we all saw was not a Form 34A, and that was therefore not the public portal. They were available on the public portal. They still remain. The particulars of that public portal, as I have said, are in paragraph 29 of Mr. James Muhati's affidavit. At the Constituency Tally Center, the results are then received either electronically, as required by section 39(1)(c) of the Elections Act, or via the complementary mechanism that I have described. The constituency returning officer then collates the results. He collects the results for all the polling stations in his constituency, and then, as directed by the regulations, compiles another statutory form referred to as Form 34B. Once this form is completed, it is then, at first instance, transmitted electronically from the Constituency Tally Center to the National Tally Center. Now, this mode of electronic transmission is different from the mode that is used by the presiding officer to transmit his Form 34A from the polling center to the Constituency Tally Center and to the National Tally Center. And this electronic mode of transmission is called the File Transfer Protocol, the FTP. It is an electronic mode in compliance, or it is an electronic manner of transmission in compliance again with section 39(1)(c) of the Elections Act. And according to the decision of the Court of Appeal of this Republic, at that point, the decision or the result in the presidential election is final. Form 34B is transmitted electronically to the National Tally Center and is then also delivered manually for the purposes of storage and record keeping to the National Tally Center. The role of the second respondent, and those of us who are present for the second respondent will submit on this in detail, again is prescribed by the decision of the Court of Appeal in Civil Appeal number 105 of this year. Without adding a comma or a full stop, the second respondent was required to add the results that were contained in Form 34B and declare a result. Those who are on record for the second respondent will confirm and will submit extensively on this that indeed was done by the second respondent, and he made a declaration as provided by Article 138, Sub-Article 10 of the Constitution of the Republic of Kenya. My lords, that is the journey of a result. And the sum total of the journey of the result is that, as prescribed by the Court of Appeal, the result must be transmitted electronically. As provided by Section 44A, the result is also transmittable manually or through a complementary system. Those two are acceptable modes of transmission of a result. My lords, I wish to take your time briefly on the impact of the decision of the Court of Appeal in Civil Appeal number 105 of 2017, the Maina Kiai decision.
Mr. Nyamodi, before you go there,
yes, my lord.
Please cut me wrong. There are these figures you said that were cast on the television screens.
Yes, ma'am.
What did you call them?
They have been referred to in my client's responses as statistics. In my submissions, I referred to them as data. But my lord, what I want you to carry away from my submission is that those figures were not the result, and they did not form the result.
What were they?
My lords, I have explained that prior to the decision, and the phrase I used was surgery. Prior to the surgery that was carried out by the Court of Appeal on Section 39, 2 and 3 of the Elections Act, those figures were what were referred to as provisional results. And what used to happen with provisional results is that they were sent electronically as text messages. And my client would then transmit, or the presiding officers and the presiding officers would then transmit either electronically or in hard copy they would transmit the physical Form 34A to the National Tally Center. And the National Tally Center would then confirm, once they received the physical Form 34A, that the results that had been received electronically...
So let's go to the polling station.
Yes.
You've completed Form 34A.
Yes, madam.
You've scanned it.
Yes.
The figures on Form 34A, you now manually enter them.
Yes.
Into the what?
Into the KIMS kit.
Yes.
Yes, madam.
What do you do with them?
You send them simultaneously.
Yeah.
You send them simultaneously to the National Tally Center and to the Constituency Tally Center.
Yeah.
And then, at the Constituency Tally Center, the first collation of the results is done. And the first collation is then sent as Form 34B to the National Tally Center. At the National Tally Center, the Form 34Bs are tallied from the 291 constituencies and a result declared.
So the ones which are entered manually are the ones which went to the screens?
The ones which were entered manually, my lord, are the ones which went to the screens, yes.
Okay.
But they were not the result, and they were not the result because of the decision of the Court of Appeal in Civil Appeal number 105 of 2017. They were provisional results. Sorry, what used to be, my lord, provisional results? There were no provisional results. My Lords, I wish now to submit on the impact, or our understanding, the first respondent's understanding of the impact of the decision of the Court of Appeal in this Republic in Civil Appeal number 105 of 2017 on the results pathway and what constituted a result. A true reading of that decision, my Lord, and I'm sure your Lordships will consider that decision in its totality when you retire to consider your decision in this matter, is that the source document that the second respondent or the Commission relies on to declare the result in the presidential election is Form 34B and not Form 34A. The argument by the petitioner in this petition that it is Form 34A that the first respondent needed to have collected all copies of before they declared the result is therefore inconsistent with that controlling or directing decision of the Court of Appeal. The Court of Appeal was clear. Once the first respondent had collected 290 Form 34As, sorry, Form 34Bs, they could then go on and declare the result. And it is stated many, many times in the responses filed on behalf of the first respondent that at the time the result was declared in the presidential election on the evening of the 11th of August this year, all Form 34Bs had been received. And therefore, my Lord, I submit that the declaration in the presidential election was made as by law required. The second issue that arises from the decision of the Court of Appeal in Civil Appeal number 105 of 2017 is that provisional results were done away with. By declaring sections 39.2 and 39.3 of the Elections Act as unconstitutional, the Court of Appeal took away the first respondent's ability to declare or to render any results in the presidential election as provisional. The Court of Appeal was clear that the results, and this is the third issue about the impact of the decision in Civil Appeal number 115 of this year, that the results, as they said, declared, but perhaps there isn't a declaration by a returning officer at the constituency, but the results declared by the constituency returning officer at the constituency in a presidential election are final. The fourth issue that arises from the decision of the Court of Appeal in Civil Appeal number 105 of this year is the interplay between the totality of that decision and the provisions of Section 44A of the Elections Act. The totality of that decision, my Lord, seems to suggest that it is the image that is electronically transmitted that is the result. The electronically transmitted version of the result, according to the Court of Appeal, was the result. The Court of Appeal, I believe, in their judgment used the terms that there was no need for 290 returning officers to troop to the National Tallying Center with copies or hard copies of Form 34B. But, my Lords, in making the finding that they did, the Court of Appeal did not declare the provisions of Section 44A of the Elections Act unconstitutional. So, my Lords, in determining the lawful manner in which results should be transmitted, other than the variable arguments that have been urged by learned counsel and learned senior counsel for the petitioners, your lordships must also bear in mind the provisions of section 44A of the Elections Act. The decision of the Court of Appeal in Civil Appeal number 105 of 2017 has a very big impact in the role of the second respondent. That point will be taken up by learned counsel who will submit on behalf of the second respondent, and I will leave it at that. The impact of that decision is also felt in the structure of Form 34C. And in my submissions, my Lord, Form 34C is coming up for the first time. And I am obliged to explain what Form 34C is. In the journey to a result, or in the journey to a declaration, the results are now all at the National Tally Center. All 290 Form 34Bs are at the National Tally Center. They are then collated into a single tally, which is Form 34C. Your lordships will note that from the statutory form that is contained in the regulations in the Elections Act, the Form 34C, as drafted or as drawn in the regulations, contains a tally of Form 34As. That was what was originally envisaged by the drafters of the regulations before the decision in Civil Appeal number 105 that rendered the provisions of section 39, 2 and 3 to be unconstitutional. The Form 34B that has been submitted to court and has been adduced in evidence both by the petitioner and the first, second and third respondents, your lordships will note, contains a running tally of Form 34Bs. And the explanation for that is the Court of Appeal directed that that is the source document from which the first and second respondent should determine the winner of the presidential election. Not A, B, 34B. So the decision of the Court of Appeal in Civil Appeal number 105 of 2017 had an impact, a direct impact, in the design of Form 34C. My lords, as I conclude on this point and move on to the next point, which I will not dwell on for as long as I have dwelt on this one, it is not lost on the first respondent that the justification for the manner in which it structured its result transmission system and its pathway to a result was largely based on the decision of the Court of Appeal in Civil Appeal number 105 of this year. My lords, the first respondents are also acutely aware that whereas this is not an appeal from that decision of the Court of Appeal, but this court doesn't lose its character as the Supreme Court when it sits merely because it is sitting to hear a presidential petition. It retains its character as the Supreme Court. It retains its character as the Supreme Court of this Republic. Your lordships may, as you retire to consider your decisions, or may not, agree with the reasoning of the Court of Appeal in that decision. And the reasoning of the Court of Appeal in that decision had a great impact in the manner in which the election was structured. But as learned senior counsel who opened the response on behalf of the first respondent submitted, the purpose of an election is to turn the will of the people into a result. I submit, my lords, that that will of the people is resident in Form 34A. there is no contestation across the board as to the validity of Form 34A. And even if your lordships do not agree with the direction by the Court of Appeal as to the manner in which the election should be carried out, we submit that that decision has not affected the expression of the will of the people. And the will of the people has clearly come through the election in respect of the presidential election conducted by the first respondent on the 8th of August this year. The second issue that I wish to submit on is the point or the issue that has been taken up about technology, the use of technology, or the requirement for the first respondent to deploy and use technology in the election that is conducted. My lords, that obligation is placed on the first respondent by the provisions of Section 44 of the Elections Act. Section 44 of the Elections Act requires or obliges the first respondent at subsection 1 to put in place an integrated technology that enables biometric voter registration, electronic voter identification, and electronic transmission of results. That system has been christened KIMS, the Kenya Integrated Election Management System. The component of KIMS that is the subject matter of this election petition is the last component, the electronic transmission of results. My lords, we have pondered about the question, what is the petitioner's complaint about KIMS? And we have despite all that has, all the information that has been out there, we have restrained our focus to what is pleaded in the petition. The petition contains vague or nuanced complaints about electronic transmission. And the principal complaint that we have been able to discern is that the petitioner complains that the electronic transmission system was compromised. Eloquently and forcefully argued, but unfortunately not backed by any evidence. It is, we submit, a bare allegation. A bare allegation, not backed by evidence, and we submit, not proved. In support of the allegation of compromise or of hacking, the petitioner has even resorted to pointing at what it perceives as inconsistencies in affidavits sworn in reply to its petition. That notwithstanding, my lords, the first respondent in the affidavit of, by way of the affidavit of James Mohati has responded to the, it has responded, my lords, and in its response, it has demonstrated the robustness of its information technology system. And my lords, I submit on behalf of the first respondent that the purpose or the reason why information technology was introduced in the elections, and this is blatantly apparent from the provisions of Section 44 of the Elections Act, was to transmit the results. Technology merely conveyed the results from one point to another. It did not generate the results. It was like a bus. It was like a matatu. It was like a courier. All it did was transport the various components of the results that I have identified from one place to another. During the pretrial, Learned Senior, who leads us for the first respondent, offered the result, offered Form 34A to the petitioner, and that offer was declined. The petitioner remains obsessed, my lords, with the mode of conveyance, not what was conveyed, the mode of conveyance. What was conveyed was either through Kim's Form 34A or through the FTP Form 34B. The first respondent has offered those for scrutiny, examination, retally. That offer was rejected. I submit that, my lords, as you retire, to consider the bona fideness of this petition, I urge you to bear that the fact that the petitioner declined the raw result in mind. My lords, because there are no tangible allegations about ICT that we can respond to, and the affidavit of James Muhato is, to say the least, very robust, I will leave the principal responses as those in James Muhato's affidavit. There is nothing on record to contradict the evidence that is advanced by Mr. Muhato. And my lords, I urge you to find that the allegations of compromise or hacking are unproved. My lords, as I take my seat, I want to leave your lordships with perhaps some food for thought. The journey around the dispute that pertains to the election or the presidential election that was conducted by the first respondent on the 8th of August this year has had some, there have been some interesting interactions between the petitioner and the first respondent. The first was a sensational allegation of hacking. A sensational allegation that the transmission system that the petitioner is so obsessed about had been hacked. At that point, we were treated even to what were referred to as logs, as proof that the system had been compromised. My lords, we have searched, and we are a big and able team for the first and second respondent. We have searched the length and breadth of the petition. We have searched the length and breadth of the numerous depositions, including those filed out of time, for the petitioner. And that evidence doesn't appear. The second piece of food for thought that I wish to share with your lordships is a letter written by the National Super Alliance, the coalition to which the political party that sponsored the petitioner belongs. That letter, my lord, is to be found on page 120 of volume 1 of the first respondent's response to the petition. And that letter, if I may, your lordships, let me just quote from that letter briefly. That letter is addressed to the second respondent. It is dated the it's dated the 10th of August 2017, and it runs from page 120 to page 124 of that bundle. And in part, it says as follows. We have information of the actual presidential election results contained in the IEBC database. The data which confirm the authentic and legitimate results of the presidential election show that the two leading candidates obtained the following votes. Raila Amolo Odinga, 8,041,726 votes. My lords, Uhuru Kenyatta, 755,428 votes. It then goes on to say that screenshots of the results as displayed on your website and monitors at Bomas show the following results. Uhuru Kenyatta, 8,056,885. Raila Amolo Odinga, 6,659,493. It then goes on to say that we have annexed the following. The actual and complete data contained in the IEBC servers, and we'll get to that in a minute. The screenshots obtained from the IEBC website. It then goes on to make 3 demands. And the most important demand is demand number 3. We therefore demand as follows: that the Right Honorable Raila Amolo Odinga and Honorable Stephen Kalonzo Musyoka be declared as President and Deputy President of the Republic of Kenya. My lords, the tallies that they refer to make interesting reading. The response by the first and second respondent is contained at page 125 to 129 of that volume, and they respond to those allegations they respond exhaustively to those allegations. My lords, you will note that in respect of Siaya County, it is a tally per county. In respect of Siaya County, the total number of registered voters are 457,953. My lords, the total number, according to this tally, according to the information that the petitioner has shared with the first respondent, the total number of votes cast in Siaya County are 482,772. More than 20,000 more than the total registered voters, according to this. My lords, the claim by the petitioner, or the demand by the petitioner, that the petitioner be declared as president is based on that arithmetic. The safeguards that are built into the election organized by the first respondent would not allow that kind of turnout in an election. This demand does not appear in the petition. The petition merely invites your lordship to find that this election was so poorly organized, you cannot tell who the winner is. My lords, at best, or at its worst, my lord, at its best, this petition, or the manner in which this petitioner has conducted himself, is a very fast-moving target. At worst, it is a wild goose chase. If it is not hacking, this is the result, or this is the election is so badly organized. My lords, there is only one conclusion. Only one conclusion, my lord, from the evidence that has been placed before you by the petitioner that your lordships can reach. This petition is not proved, and this petition should be dismissed with caution. Unless, my lord, there is anything you wish me to clarify, that is all I wish to submit this afternoon.
Thank you, Mr. Modi. Yes, Mr. Manzoor.
Yes, my lords. I pick up from where Malani Senior has stopped, and specifically, I wish to respond to the figures that were given to the court by my other learned senior, Mr. Atende Amolo, for the petitioners, and I'll do it sequentially in terms of the figures that he gave and the allegations that he made. The first one, my lord, was the allegation that the forms were not in the prescribed manner under the regulations. With regard to Form 34C, Malani Senior has answered that. To the allegation that all the forms that they scrutinized in terms of Form 34Bs and 34As were not stamped, Our first submission is there is no requirement in law for the stamping of these forms. No regulation was given to you, and none exists. Ballot papers, yes, the regulations require ballot papers to be stamped. The case was not ballot papers were not stamped. All the ballot papers used on the 8th of August for the presidential election were stamped at all 40,883 polling stations. In the schedule to the elections regulations, the forms, the prescribed forms as referred to under Section 39 are set out. When, my lords, you retire and look at the prescribed forms in the schedule, and they all follow each other, there is no provision for stamping in the forms, except the forms that come up with D, the certificate to declare somebody elected. But those are not the forms, those are given after the declaration, either at the constituency level or at the National Tallying Center. But Form 34A, B, and C in the schedule do not require any stamping. And you notice that no regulation was referred to the courts because none is provided for in the regulations. The handover notes, that has been explained. The forms were authorized for printing before the Court of Appeal delivered its decision. When returning officers used to troop to the National Tallying Center, the requirement for them to give and sign the handover notes was in the forms. By the decision of the Court of Appeal, those results are transmitted electronically or through the complementary system. And from the Constituency Tallying Center to the National Tallying Center, the EFP format is applicable. Now, the handover notes used to apply when all these constituency returning officers had to physically come to Nairobi because what they had declared at the constituency were provisional results, and then come and hand over to the presidential returning officer, who's the second respondent. With the Court of Appeal nullifying that old process, there is no requirement for the handover notes to be filled. The forms are electronically transmitted, and therefore the handover process no longer applies. So for the requirement for them to say that these handover notes were not filled and the form was not stamped, that was not a requirement under the law. And as far as the procedure is concerned, there was no irregularity in the manner in which the forms were filled by all the constituency returning officers. Now, there was an allegation by Malanet Senior that the forms that were used in the whole process of elections did not conform and did not have the security features. This is not correct. This has been answered in the affidavit of Immaculate Kasait, and my lords, you'll find this in our volume 2 of the IEBC responses. It's written volume 2, court stamped 24th of August 2017. The affidavit starts at page 196 of this volume 2, and the specific security features, because of time, are to be found at paragraphs 214 to 215. The actual page is page 241 in the affidavit. And there are 8 features that run across all the materials that were used in the elections. In terms of the genuine forms that were used at the constituencies and at the polling stations, as well as that were submitted to the National Tallying Center, these have been submitted to the court. The court will have an opportunity within the 48 hours prescribed under the Supreme Court election petition regulations. All the genuine forms are here, and the features will be there for the court to be able to examine. As I wind up on this issue about the stamping of the forms 34A and 34B, my lord, I will refer you to our submissions and your decision. Our submissions at paragraphs 38 to 41, and the decision of the Supreme Court in the case of Nadif Jama Adam versus Mohammed and 3 others. It is now reported in volume 3 of 2014 East Africa Law Reports at page 177, and the excerpt that we rely on in our submissions is to be found at page 202. And in a nutshell, that decision says this, that even if stamping was a requirement, and we have said the stamping was not a requirement under these forms, it is not enough for a petitioner to allege that the forms were not stamped. You must go further and attack the results as contained in those forms and show that those forms are not, those results are not genuine, they are not valid results. And more importantly, as far as Form 34As are concerned, that those results were challenged at the polling station. And either an agent signed on the form saying, I do not agree with the results as set out in this Form 34A, and therefore I'm not appending my signature, or you go further and have an affidavit. And in this petition, there is not one single affidavit challenging any of the results as declared in the 40,883 polling stations. So stamping is not an issue that this court needs to waste time dealing with, because it's not a requirement, it does not go to the results that were declared, either in Forms 34A or in Forms 34B, where the agents were present at all the 291 polling stations. So it's just not enough. This court has stated the law, you must go further and challenge the results. That has not been done. My Lords, you'll have time to look at your decision. Well, there was an allegation about the barcodes, and this allegation, my Lords, came out in the submissions. It was not set out in any of the affidavits that we had originally to respond to. But my Lords, barcodes have to be understood. All the forms that required barcodes, other than the ballot papers, and we have set this out in the affidavit of Immaculate Kasait, the barcode corresponds to the serial number that is put in each form. And as far as you have a correct barcode reader, it will actually confirm that the serial number on each of this voting material is correct. The allegation that this material, once it read, it showed other places, is a fact and a confirmation that they were not using the correct barcode readers, because all these forms, and once the forms, the genuine forms are looked at, the ones that were submitted to the court, it will confirm that the serial numbers correspond to the details that are set out in each and every form, in terms of the area code, in terms of the constituency code, and even the ward where it comes to the constituency tallying center. And, my Lord, the only possible explanation why they got funny results is because when you use Android phones or phones that connect directly to the internet, they pick up some of those numbers. And this, because the barcodes that are put for each and every form are specific to that form, they will go searching on the internet to find any other corresponding codes. And that's where you start finding it taking you to different places. But when you use a barcode reader, a proper one, for purposes of these forms, you actually get the correct results. Well, there was an allegation that there was an attempt to tamper with the forms when they compared the results, that the forms that they had been given and the results that were submitted to this court. That is not true. All the forms that were given and the ones that were supplied, the genuine forms were supplied to this court. There has been no tampering with any form. And in fact, when you retire and look at all the forms that were presented to this court, they tally with what was declared first, what was announced at each and every polling station, what was aggregated at the constituency tallying center, and then what was considered in the declaration of the results of the third respondent being elected as the duly elected president-elect. There has been no consistency, and none was given. There was only a vague allegation that the forms were tampered with. By who and how? The genuine forms are here. They were submitted to the registrar of the Supreme Court, and all those forms can be looked into. Those forms have not been changed. Those are the forms that were presented to the first respondent and to the second respondent. In terms, there was an allegation that there were some forms that were filled by returning officers who were not gazetted. This allegation is also not correct. This, in terms of the facts, has been answered in Mr. Ezra Chiloba's affidavit at paragraph 5M, to be found at page 142, of Volume 2 of our joint responses. And my lords, in terms of the gazetted returning officers, the error on the part of the petitioners is that they only looked at the original Gazette notice. There has been, and there have been, corrections in the corrigenda and subsequent Gazette notices as set out in the affidavit of Mr. Ezra Chiloba. In the interest of time, I'll quickly give the court the dates when all these substitutions were done properly and gazetted by the chairman, who is the second respondent, as required by law. And these ones are set out in that paragraph, paragraph 142M, but I just want the court to have the dates of the Gazette notices. The first one is a Gazette notice that was published on the 5th of May 2017, being Gazette notice number 4410, which gazetted all the 47 county returning officers and deputy returning officers. On the 26th of May 2017, Gazette notice number 4979, this is 26th of May 2017, the first schedule made changes to the deputy county returning officers. There were 2 of them, but more importantly, to the allegations about the 10 constituencies. This was effected, the changes were effected by Gazette notice number 4980, dated the 26th of May 2017. My lords, when you try and look at these Gazette notices, they changed the constituency returning officers with respect to 10 constituencies, the exact same number that was given by Malanet Senior. And what they did is that they were transferring these constituency returning officers from one and replacing them, and this was done, it was at random throughout the country. And my lord, in the interest of transparency, my lords, you'll find when you retire that these changes were effected not only on that date, but there were 2 subsequent changes. One was effected on the 4th of August 2017, and the last one, the 4th of August, is Gazette notice number 7591. It was also a corrigenda amending the original Gazette notice that the petitioners are relying on. These are public documents. The fact that they did not read them does not invalidate the act of the chairman of the IEBC. And the last one, the last change was effected 1 day to the election. This was done on the 7th of August 2017, and it only affected 1 deputy returning officer, and this Gazette notice was number 7618 on the 7th. That was on the eve of the election. So even on the eve of the election, the chairman, who's the second respondent, and the chairman of the first respondent was aware of the requirement to effect these changes, and that was done. My lord, so in terms of this 10, you had been asked not to consider the results, the 594,476, because these returning officers were ungazetted. That is incorrect. Those results, which are spread across 8, all the 8 candidates, were valid results and should and were properly considered by the second respondent in the declaration of the results. My lord, there was an allegation, and I think it has been answered adequately by Malanet Senior, that at the time of the declaration of the results, 10,000 forms equivalent to some 7 million votes had not been availed and not considered. That is incorrect on the basis of the explanation given by Malanet Senior. But more importantly, when you look at the petition and all the supporting affidavits, the requirement of particularity, they have not identified this 10,000 odd polling stations number by number, how many votes were cast, and the assumption that each of these polling stations had 700 voters is not a realistic assumption. Why? Because the number of registered voters, the maximum was capped at 700. The actual number of registered voters varied from 3, as we have shown in the affidavit of Immaculate Kasait, to 600 and something. But more importantly, that is the registered voters. How many voters actually turned out to vote on that day is different. So these are 3 different parameters. It is not for a petitioner to assume all 700 voters who should have been registered as a maximum would have turned out and that they would have voted. That is a figure that was plucked from the air, and the court should not consider it when it makes its determination. The actual number is 10,840. My lord, with respect to the particular results that had been given, I'll quickly go through because of, in the interest of time. The rejected results, my lord, this will be addressed at length by my colleagues who will be submitting on behalf of the second respondent. The actual number in Form 34B, which is the result, was 81,685. Not 407,000, not 437 or 395, 81,685. My lord, you were given 25 samples by Mr. Molo Otende of results from Igembe South, Rabai Road. He went all, my lord, in the interest of time, this has been answered in detail in the affidavit of Immaculate Kasait. And in particular, my lords, when you retire, I just want to give you the numbers. This have been set out in the affidavit of Dr. Nengiso Odua in terms of the figures and the allegations, my lords. They are incorrect allegations in the following paragraphs, my lords. I'll just give them so the court can consider them. Paragraphs 27, 28, 45, 51, 52, 53, 56, 57, 59, 62, 63, 65, 71, 72, 73, 85, 87, 88, 92, 96, 98, 132, 133, 134, 136, and paragraph 140. And in the affidavit of Ms. Kasait, what she has done, she has sequentially answered each and every allegation in Dr. Nengiso Odua's affidavit. My lord, you'll have time to look at it. And because of the interest of time, I'm not able to take you. I would have been able to take you, but I keep one eye on the clock, and I have to. But those allegations have been answered, and the correct Form 34A and 34B given in the affidavit of Ms. Kasait. Mrs. Kasait. Lord, in terms of the gazetted polling stations, I want to quickly wrap up on that. My Lord, there were no results that were declared from ungazetted polling stations. My Lord, this has been answered at paragraph 192 of Immaculate Kasait's affidavit. This is an answer to paragraph 211 of Dr. Nengiso Odua's affidavit. It has also been answered at paragraph 200, and this was an answer to paragraph 219 of Dr. Odua's affidavit. In fact, my lords, when you return and look at those two paragraphs, those polling stations and some of those polling stations that have been referred to by the petitioner do not exist. My lords, I repeat this for emphasis. Read paragraph 192 and paragraph 200 of Immaculate Kasait's affidavit. Those allegations, those are not gazetted polling stations. The polling stations are set out in the Gazette notice, and we have shown them. And my lord, as a wind up, there was an allegation that Muhammad Nur Bare and Muhammad Ibrahim Muhammad had attested to results coming from ungazetted polling stations. That is incorrect. When you retire and look at these two affidavits, first, these were presiding officers who had initially been engaged by the first respondent, but they never went through the mandatory training. They never took an oath of secrecy, and they were never given any letters of appointment for the polling date. We have put this in a replying affidavit that has been sworn by the county returning, constituency returning officer, Abdi Bashir Ali Nur. You will find this at page 436 to 439 of Immaculate Kasait's affidavit. And he has also answered the allegation there was a constituency tallying center that had been declared null, that had been invalidated by Justice Mwita. The Court of Appeal decision that stayed that order has been also produced, and my lords, you'll be able to find this at page 472 to 473 in that affidavit, and that's paragraph 29. This stay order was given in civil application number 188 of 2017 by the Court of Appeal on the 7th of August. So, my Lord, as I wind up, in terms of the numbers, the results as declared, in fact, where there have been posting or transposition errors, we have considered this in the affidavit of Immaculate Conception, and the respective presiding officers have sworn affidavits explaining the circumstances under which the errors were made. There were innocent mistakes. The numbers are very insignificant to the final result, and my lords, you'll be able to see these affidavits from page 352 all the way down to page 650. Those are presiding officers who have sworn affidavits addressing two things: the issue about the results being wrongly posted, and two, they have also sworn an affidavit on the allegations that some returning officers were chased away from Embu County in several constituencies. They have answered one by one, explaining all those issues. I can see I only have 1.5 minutes. On these issues of figures, my learned friend, he was to assist me, and only on 3 issues which will take only 1 minute. May it please the court.
Mr.
Somani.
No, just a minute, Mr. Mansour.
Yes, sorry, I forgot to ask whether you had any questions.
No, you don't have 1.5 minutes. You actually have 1 hour.
Oh, sorry.
Yes, so go on. Because you are sharing it.
Yes, we're sharing.
Yes. We are sharing, just like the court is very strict. We are also strict amongst ourselves.
Yeah, that's why I wanted to correct that wrong impression.
Yes.
We haven't taken away your time, so you still have that time. Yes.
May it please the court. There are 3 allegations which have been made by the petitioner as relates to the accuracy and the accountability of the results transmitted by the second and the third respondent. The first allegation relates to the fact that there are 482,202 people who walked into the polling station and voted for other county seats, who did not vote for other county seats but voted for the president. We say this allegation is inaccurate. We refer the court to the affidavit of Immaculate Conception at paragraph 208, and we refer the court to the annexure EC 12. We state that if the court directed itself to the variance of the gubernatorial, the senatorial, and the women rep as it relates to the presidential, you will find that the variance can be accounted for, number 1, by the diaspora voters who are voting for the presidential election. Number 2, by the prisoners who are only voting for the presidential election. Number 3, by the stray ballots, which can only be accounted for by sorting if all the ballot boxes are brought and sorting is done. And number 5, by the rejected votes. I will, much obliged, my lord. My lord, there's an allegation which has been made by the learned senior for the petitioner that 482,202 persons walked through the polling stations on the 8th of August and voted for presidential candidate and did not cast their votes for the governors, for the women rep, and for the senators. This allegation is inaccurate for the following reasons. Number 1, if you look at the affidavit of Immaculate Conception at paragraph 208, we have annexed a variance analysis of the vote for the various seats. And a variance analysis for the votes for the various seats will prove the following. The variance or the difference between the persons who cast votes for the governor's seat in the whole of the country and the presidential seat is 0.271%, or 41,104 votes.
The variance for the persons who cast vote for the senatorial seats as compared to the presidential is 34,243,000 or 0.226%. The variance of the persons who cast their vote for the presidential as compared to the women rep is 74,416 or 0.419% of the vote. We submit that the variance is accounted for by the following. Number one, the diaspora voters were only voting for the presidential candidate. Number two, the prisoners were only voting for the presidential candidate.
We seem to have some misunderstanding. Our understanding was that both the first and second respondents had a total of 3 hours. And the third respondent had 3 hours. And then we had 1 hour. So that if this is a continuation of representation for the first respondent, then they are clearly out of time. But if it's for the second respondent, we have no problem.
No. It is combined. We are doing it for both the first and the second respondent, 3 hours.
Then that's okay. Yes, and he said, Mr. Mansour said they have got only 1.5 minutes.
No, let me correct that. That's why I corrected him. The first and second respondents are 1.5 hours each. Third respondents are 3 hours. Yes.
My Lord, I noticed in that interjection my time was running. If I could be added on. If I could be added. Yes. My Lord, if I may continue.
Yes.
The variances can be accounted for by the following. By the diaspora voters who are only allowed to vote for the presidential candidates, by the prisoners who are only casting votes for the presidential candidate, by the rejected votes, and by the strayed ballots, which could be confirmed by sorting. And my Lord, in our submissions, we have indicated that this was so accurate that it actually falls within the internationally recognized threshold. The internationally recognized threshold is plus or minus 5%. We are at less than 0.27% when you combine all of them. My Lord, our submission is that there is no one, there are no 482,000 or 800,000, as has been sensationally claimed, who voted for the presidential candidate and did not vote for the other seats. It can be accounted for, it is accurate, and to the submissions of the learned senior that in our voting system, there is no way that the presidential, someone will vote more for the presidential than the other seat. That is not accurate. You have prisoners and you have diaspora voters who vote for certain candidates. That is the first allegation we wanted to answer. The second one, an allegation has been made that there was an inbuilt variance of 11% from the time of transmission of results. We refer this court to paragraph 9 of Immaculate Kasai's affidavit. We have done a tabulation of a 30-minute period and a 60-minute period. And if you did that, my lords, you will come to the analysis that the differential variance ranges from 9% to 25%. To a low of 9%, the number is actually 9.02%, to as high as 25% between the candidates as the results were coming in. We say that that allegation is unfounded. Our client, the first respondent, has no a candidate favorite. He did his duty as per Article 6 of the Constitution, and if a tally is done of all the 40,883 votes, you will not come to any other conclusion except the conclusion that the first and the second respondent came to. My Lord, a third allegation was made in Dr. Nyangasi's affidavit that results started streaming at 5:07 p.m. We find this allegation to be startling. The first respondent is being accused of being very efficient. And we also find it startling because the petitioners know for a fact that there were polling stations with 1 voters, like Lowangina Primary School in Tigania East. There were polling stations with 3 voters, like Algana in North Hor and in Matuga constituency. The same has been captured in paragraph 8 of Immaculate Kasait's affidavit. And if you looked at the various polling stations which have less than 10 voters, it is expected that the results will come in immediately, the close of the polling. The same allegation is untrue, and we submit that these were the results which started streaming in, which had less than 10 polling stations, which had less than 10 voters. My Lord, unless you have a question for me, I had only 5 minutes, which I have taken from my senior Kamau Karori. Thank you.
Lord, before I start, the case for the second respondent, I don't know whether my Lord, in view of the time that is expected, whether it is possible to take a short break before we start the second respondent. Why? Not short hands, if it's possible, because we've been sitting for the last number of hours. No. Okay, all right. Lord, I've been corrected by my seniors at 2020. My Lord, before I start the case for the second respondent, let me just say this first and foremost. One of the allegations that has been made here, and it was made when the TV was put on, is that Mr. Muhati took over from the late Musambo after the deceased passed away. That is a sensational allegation that is false. Mr. Muhati was in office prior to Mr. Musando passing out. So it's a false allegation that Mr. Musando passed away and then Mr. Muhati was recalled back to office. That is not true. And it is important to clarify that point because of the insinuation that was being made regarding the coming back into office of Mr. Muhati. The correct position is that Mr. Muhati was in office at the time of the serving nights. My Lord, this petition brings to the fore the competing interests between a challenge to an election by a party and the interest of ensuring the protection of the sovereign will of the people, which has been discussed at length before you today. Now, my Lord, one of the defining characteristics of the Constitution of Kenya that is very different from the other constitution is the emphasis on the dignity of the people. That is one of the most defining characteristics of the Constitution. In fact, my Lord, you'll find that in Article 28, there is a specific article that deals with the dignity of the people of Kenya. Why that is important, my Lord, is that on the 8th of August 2017, people queued and voted and cast their vote for their preferred candidate. It is critical that this court protects and defends the vote that is cast by every citizen. My Lord, this will of the people, or the sovereignty of the people, is then realized through Article 81 of the Constitution, which establishes the electoral system and processes. And one of the principles is the holding of free and fair elections using the principles set out in Article 81 of the Constitution. And this is what is critical, my Lord. There is no suggestion that has been made that there was no election held on 8th of August 2017. There is no such allegation. There is no allegation, my Lord, that has been made that the principles set out in Article 81 were not complied with. And I say this because, my Lord, one of the requirements is that the election to be held must be held by way of secret ballot. There is no allegation that that was not done. There is no allegation, my Lord, that has been made, and this is the critical component of what, in addition to what my Lord and friend said, that the information set out in Form 34A, I'm not talking about the time, I'm talking about the votes recorded on Form 34A as having been received by each of the presidential candidates. There is no allegation that that is not correct. It is the most important component of an election that in this polling station, one candidate received 6 votes, the other candidates received 15 votes, that all the 40,883 polling stations. The second issue